Thank you. I'm Dan Kilkenny from Belgium, Wisconsin. I want to thank Ronnie for inviting me. Carl Whiting, who I've talked to over the past few months regarding the pipeline. I'm on the Walworth County Board of Supervisors as well. So again, my name is Dan Kilkenny. Need to get a little closer. Dan Kilkenny. I'm an attorney in Walworth County and have been practicing for, I guess, a little over 30 years. I'm also a Walworth County Board of Supervisor, as I mentioned. I'm on the town board of Darien as well. This last fall, I ran for the Wisconsin State Senate. So I do different things. I also manage our local nonprofit cemetery. I tend to probably get bored and like to do different things. They've asked me to speak tonight, I think, because of the broad experiences that I've had. And I see with all the recording devices here, I want to have some caveats. I am an attorney, but I don't do litigation. I haven't handled any eminent domain cases, and I'm not looking for work, so don't call me. I've had my practice slow down quite a bit. I limit my practice pretty much to people I like and things I enjoy, which gets smaller and smaller. Anyway, so again, I'm going to be giving some very brief overviews, and so again, don't rely on this or think that if you do get in a pickle or have important issues at stake that you don't get your own attorney or work with groups that have one. Before I get in, I guess, on my topic, I would want to mention something. There was mention of the environmental impact statement that was done in 2007, and I've talked to Carl about this. When I was on our county board, we were looking at doing a resolution. And one of the things that struck me in the environmental impact statement, which is supposed to be a analysis of costs and benefits, and one of the main assumptions or presumptions of the study was that in the United States, fuel use was going to continue to skyrocket and domestic production was going to continue to decrease. And of course, as Elizabeth mentioned, with millennials, different people, actually the use is not going up that much. And now with fracking and other things, actually, we're expected to be the leading producer of oil. And so I would ask other people that are interested in this, it may be something to look at. Again, if you're looking at that environmental impact statement, is to question that fundamental premise that we have to have this pipeline because use is going up and other production is going down. So anyway, I'd like to get into the eminent domain portion. I guess I've already heard some laughter. I was going to say normally you like to start out with a joke, but there's really nothing funny about eminent domain. But first, the basic right comes from the Constitution, the Fifth Amendment, amongst all sorts of other things. It says that private property cannot be taken for public use without just compensation, which the real easy part is private. Well, that's my land. But when you get into public use, you know, people may argue, is this appropriate public use or not? And then finally, just compensation, what is just? And so the whole process of the eminent domain deals mainly with just compensation. You can get into issues about whether it's truly a public use, but that's a pretty difficult thing to argue. We need oil, pipelines provide that. It's probably not going to be a real fruitful area, but something that you may want to take a look at. There's also state eminent domain, and there's some federal regulations that come into play which I really know nothing about. So if that has some elements, it would be something you want to look at. My family's had an experience with high voltage line transmission going through one of our farms and a gas pipeline through one of our farms. The electrical transmission line, we got them to take a different route. Unfortunately, couldn't do that on gas pipeline. So I've personally been through this process, which may be another reason why it's appropriate for me to be speaking. But there is information available. One of the things I have that I looked at and brought today was a pamphlet put out by the Department of Commerce and the Attorney General's Office, The Rights of Landowners Under Wisconsin Eminent Domain Law. So if you Google that, you'll be able to find it. It's got a nice little flow chart in the back about how the process goes. And so I'll basically just follow on the flow chart. Essentially, at some point somebody will knock on your door, send you a letter that says we're interested in your property. That kind of starts the process. And the process works, the company is supposed to provide you with an appraisal of the land that they're trying to take or the value of the easement that they're trying to acquire. You then have a right to get your own appraisal, and if it meets the guidelines, the company should pay for that as well. At the end of that, they negotiate with you. If negotiation's successful, they'll cut a deal. They record what's called a certificate of compensation with the Register of Deeds, which says what your compensation is. And you do have, I'm not sure the appeal time, I think maybe 6 months or 60 days, but you can appeal even though you agreed to that at a later date. The other avenue, if you don't have a successful negotiation, you can ask to have the matter heard, and that's generally heard by a local, I think the exact term is compensation commission, which looks at the evidence and determines a value for your real estate or the easement. If you're unhappy with that, or the company's unhappy with that, both of you can appeal and have that award looked at by a circuit court to see whether the award is appropriate. If you do far better, I think it's 15% better than the award or offer of the company, you sometimes can get attorney fees. So the process, though, is relatively, I guess, straightforward in terms of these values, but how you argue it, what the various issues are, depends on a case-by-case basis. And I know some of what it sounds like the expansion is going to be along an existing easement, which raises a different question. First time through, they may say, well, your property is not going to be affected too much by our pipeline. Second time through, they say, hey, we kind of destroyed your property. It's really not worth that much anymore. There's no requirement that they be consistent. One of the things I'm kind of bouncing around here, but again, just trying to hit some highlights. One of the things that I was a little bit amused at with the pamphlet from the state, it says the goal is to achieve equality of information for both parties during the negotiation process and to reach satisfactory settlements equitable to both the property owner and the public through the statutory process. Being a landowner going through this, you have this short time period, we want to acquire your easement. What do I know about it? Not much. What's an easement worth? I don't know. You have a company that has got thousands and thousands of miles of these, negotiates every day, has far more information than you do. So you're never going to have that balance. So it's important to get involved with groups, research, and to get good legal help. Look at that, and in terms of getting good legal help and information, again, the broader you can, the more people you can work with, the more groups and organizations, the better informed you'll be, and the more likely you'll have a good result.